Good morning, everyone. Bom dia a todos. My name is Isabel Gomez, and I'm the president of the Brazil-Minnesota Chamber of Commerce, the organizer of today's event. The Brazil-Minnesota Chamber of Commerce is a Minnesota corporation that has been established to promote cultural, social, education, and commercial relations between Brazilians and Minnesotans. You can learn more about us by visiting our website, brazilminnesotachamber.org. Again, brazilminnesotachamber.org, Brazil with a Z. This event is also brought to you by our sponsors, the law firms CGM Advogados, based in São Paulo, and Fredrickson and Byron, based in Minneapolis. We also have the institutional sponsorship of Abra Filtros, based in São Paulo, and the Minnesota Trade Office in St. Paul. It is on behalf of the Minnesota Chamber of Commerce and our sponsors that I welcome all of you joining the webinar today. I also welcome our moderator, Adriano Chaves, co-founder and partner at CGM Advogados, and the esteemed members of the panel, all of whom extremely qualified to share practical and timely views on the Brazilian data protection law, and they will go a little bit into the other regulations as well in the US and Europe. Adriano will briefly introduce the panel, and I'll pass the floor to him shortly. We have planned to have the panel address Adriano's questions for about 45 minutes. Meanwhile, please use the chat feature on this platform to pose your questions as well. I will be on the backstage organizing the questions, and I'll come back around 15 minutes to the end to pose the questions to the panel. Adriano, please take it away. Thank you, everyone. Adriano, I think you are on mute.
Sorry. Thank you, Isabel, and the board of the Chamber for the invitation. It's a great pleasure to be here. Good morning, everybody. Welcome. I would rather be in Minnesota. It would be much nicer to have a presential meeting, but that's impossible right now. So let's take advantage of the technology that actually brings us to this important issue, which is data protection in Brazil. So our goal today will be to discuss from a practical perspective the impacts of the Brazilian data protection law, which LGPD, which has been enforced for 7 months. So we already have some lessons that we learned, and try to give you some insights on how companies have been handling the challenges so far, and to get prepared for the new phase, which starts in August 1st, when the penalties will come into force. So I would like to briefly introduce the speakers, this amazing team. So they have, many achievements in their career. So I'll briefly explain or address the latest ones. So we have Carolina Gladier Rabelo Sachs, Head of Legal Institutional of ABBC, the Brazilian Association of Banks. She has a PhD in economic law from the Pontifical Catholic University of São Paulo. We also have José Saul Moscati, managing partner at DGT+L, a consulting company focused on the implementation of automation and integration of technologies applied to legal services, former managing director of Accenture, market unit legal lead in Latin America. He has an LLM from the University of London. And Diana Rosenberg, Brazilian attorney and privacy specialist with experience in global privacy laws. She is a Juris Doctor and Master of Laws from the University of St. Thomas. So welcome, speakers. It's great to have you here. So I'll start with a question to José Moscati. So when we presented a similar webinar in September last year, we had lots of doubts of what would happen, how the market, the companies would react, how the data subjects would react to the new law. Now, 7 months later, how do you see the situation of the companies in terms of adequacy? What has surprised you positively or negatively?
Thanks, Adriano, and thank you for the kind invitation, and thank you for the other panelists and for the audience. And thanks, Isabel. So, Adriano, so we had several expectations before the law came into force. We were afraid of having an avalanche of requests, but this did not happen. So we had very few requests, and most of these requests did not follow the channel of the authority, ANPD. And why we have some certain guesses why this happened. So one is because the way the law came into force was by phase. So there's the penalties will be applied only after August. The other thing is that other channels were used, like the consumer authority, so complaints were made there, and also through non-governmental organizations, like the ones that you complain in a forum, and this is made public. Thinking again, this is in line with what we see in the internet, where reputation is the most important thing. So people, they get what they need when they put the image of whoever they want to complain about in public. And then because the answer is really fast, because this is damaging their image, their public image and reputation. So what we're expecting as an avalanche did not happen. And also, maybe as a consequence, what we're expecting as a big demand of legal services and legal technologies to make the company compliant, we did not see an avalanche also. So, of course, there are requests. Of course, everybody's trying to get adjusted. But I read a survey from ICTS, and they say that 84% of the companies are not ready for the new law, not new anymore, for the law. But this is all consistent with this scenario. And even when asked, the authority, I had the pleasure to participate in a meeting where I could ask the director of the ANPD, Mr. Valdemar Gonçalves Ortunho. And then I asked him if they will start imposing fines from August onwards. And the answer was that no, they will go for a very smooth process, which I think is good. I think when we don't hear too much about the agency is a good thing. So I think the terrible scenario did not happen. The best scenario also did not happen. So I think it's good news.
That's very interesting. I think we're going to have a process that is similar to what happened in Europe, right? Where I saw a survey after 1 year of the GDPR, and basically they found out that 50% of the companies after 1 year felt that they were not compliant with GDPR. So it was after the GDPR was in effect. And 1 in 5 companies thought that full compliance was impossible, which is actually quite amazing, right? And after 1 year, the lawyers realized that fewer fines were given in comparison to what they expected. So the amounts were not high. So the authorities in Europe tried to educate first, and only later they started imposing penalties. And what happened also was that the enforcement agencies were overwhelmed with work. So they were not really prepared to respond to the demands that appeared. In Brazil, I think we are having a similar situation, and actually we may have even a more critical situation because ANPD started really from scratch, right? The authorities in Europe already were working before GDPR was organized. So here ANPD started from scratch. The president of ANPD mentioned that this is a big challenge for them. They will have up to 36 people only, right? If you compare with Spain, it had 181 workers and a budget of 14 million euros. So if you compare to NPD, they're really starting from scratch. So can you tell us a little bit what's your impression of the composition of the NPD and the profile of the directors?
So Adrian, when there was the announcement and the profile of the directors, we could see that there were many military personnel, including the president. At the time, and I did share in one of your seminars, that I was concerned that this would indicate that they would be subject to the federal government. We did not see that. So all the interactions are being very cordial. They're very open. They're putting to a public consultation key aspects of the enforcement of the law, including establishing safe but lower standards for medium and small business. So what my concern did not materialize. So although they are composed by a great percentage of military personnel, they're being very discreet and showing some independence, which is good. And also now there will be the election of the board, and there are many indications from union, civil society, and so on. I think there are more than 100 people that were indicated for the position, and I think this mix will be good. So I saw many good names there. Also, even the military personnel, they have technical background, mostly on security, which is somehow connected to data privacy. And from what we see in the news is when there's a big breach. And after working on implementation of systems, because I'm a lawyer that's moving to the technical area, I'm learning that it's harder for the company to be secure against breaches than to comply with the law, and the risk of a breach is the biggest risk today. So I'm pleased with the way the ANPD is evolving. All the fears we had about the composition are not being they're not materializing. Okay, so I take it back, my concerns that I shared in the previous interactions.
That's great to hear. And my impression is also that they are very technical, very professional, and very accessible. So that's great news for Brazil. As you mentioned, data breaches, I think that's a major concern in Brazil. Everywhere, actually. Every day we open the newspapers, there's a new data breach. And Carolina, I think it's quite amazing that at least we in Brazil have not seen any major data breach involving a bank or a payment institution. That's at least my impression. So is there any reason for that? Do you think that the cybersecurity regulations enacted by the central bank played a role on that? Can you give us your thoughts on this? You're on mute.
Sorry about that. Just breaking the ice. Hi, everybody. So thank you so much for spending some time today. It's always a pleasure to be in touch with professionals I admire so much. And thank you for the kind invitation. So going straight to the point, Yes, Adriano, I really do believe that we had some work before the LGPD implementation, but not just with the 4658. That is the regulation on cybersecurity and cloud computing. We had previously the addition in 1964 of a law that tried to create the whole financial system that we know nowadays. So on its 38 article, we have like the embryo of the confidentiality and this kind of obligation. Moving on, for 2000, 2001, we had the complementary law 105 that is restricted to the confidentiality in the part of the financial system. So we had a lot of other iterations. We had a lot of other work previously to LGPD that made the financial system a place a little more secure than the other industry that had to implement, to understand the new movement, and try to make from nothing sometimes a real deal, this big change. So I believe it's like two way, not only way out.
Excellent. Yeah. So, as many companies were not prepared in September, our focus when we were advising clients were really on that. We really have to focus on cybersecurity because that's one of the main vulnerabilities, on how to channel, the requests from data subjects so that, you don't get entangled, if you have a lot of requests, and generally, in updating and making public our policies and so on. So cybersecurity was one of the main pillars of that strategy. And I think, of course, it still remains that important. Another question. ANPD mentioned its plans to regulate several points of the LGPD only next year. And some of the items will be regulated only the second semester, such as, international data transfer, the rights of the data subjects. So how did the financial sector receive this? Any concerns?
Well, this ordinance, the 11th, brings just the 10 priority themes for the biennium for 21 and 22. And sincerely, the market as a whole does not have complaining yet, because we are just trying to implement to compliance and to create new internal controls to make the law how can I say something to be in compliance, because it's really hard even for us banks that have this duty of confidentiality to create new internal controls. We have a lot of other things to deal with, so the central bank is being like a real father to us, helping in this kind of implementation and in this space of a new reality. So personally, I do think that ANPD must bring soon the definitions about how some things must be faced until they are not regulated. So I don't know why they did not yet release that list that the GDPR and the European authorities released about the countries classified according to the degree of protection. So thinking about in international transfers, this would be, the first step. So I don't know why, but they may have a reason, and we are here just, waiting to discover the follow steps.
That's a great point. I'll try to address that with Diana later, but I can already ask Diana one important question which I think will help people visualize, how LGPD applies. Can you tell us a little bit about the differences between LGPD and the California law, which is this called CCPA?
Of course. Can you hear me?
Yes.
Okay. First of all, thank you for inviting me for this conversation. I feel very honored. So the first difference is the territorial scope. CCPA is much more smaller in scope because it covers any for-profit that does business in California and process personal information of residents in California. So putting in simple words, because I'm speaking to a commerce chamber, you can be subject to California law if you make over $25 million in annual gross revenue, as long as you have one California customer, or simple derives 50% or more of your profit by selling personal information of California residents. On the other side, LGPD covers any business or professional, regardless of the size of the business, whether they exist in Brazil or not, because the key point is that you handle personal information in Brazil. You handle or collect personal information in Brazil. And that can be through having a website available to browse in Brazil, for example, and also asking the question that was made through the comment. This is an easy way to catch personal information in another country by using cookies. So you would be subject to the Brazilian law. Another difference is how they classify personal information. So while LGPD is very broad, that means almost everything can be personal information for LGPD if the data is able to identify a person. And on the other hand, CCPA defines more specifically as personal data, an information that can be used to identify a natural person. And it can be a name or social security, an address, and information that can be used to identify a household as well and a device. So also if you have cookies and you catch an IP address from a device in California, you can be subject to California law. And the last major difference is that LGPD allow you to process personal information on 10 legal bases, while CCPA tells you that you can process California's residents' data however you please, as long as you give the rights to opt out and specifically have a button to do not sell my information. So yeah, in conclusion, that means that we have to draw a specific privacy program designed to attend those legal requirements.
Well, you mentioned something very interesting, the word sell. I found this very interesting when I read CCPA, because I find that, GDPR has a different approach to the matter of privacy. They treat this as a fundamental right, as a human right. So they use words like share information, share data. LGPD use the same concepts. I think CCPA takes a more capitalist view of the subject, and they use the word sell. They are less discreet, so to speak, which I found very interesting. And that reflects throughout the law. For instance, I found it very interesting that GDPR and LGPD, we have what we call the opt-in, right? So you really need to, unless there is another legal base, you really need to consent for someone to use your information. In the CCPA, the standard rule is the opposite, right? It's the opt-out, with some exceptions, of course. So this is very interesting and shows how different countries think. Take a different approach on the subject, right? Yeah. So, but for multinationals, I am sure many of our listeners work for multinationals. They have to handle GDPR, the Japanese law, Brazilian law, Argentinian law, CCPA. Now we have other states in the US also approving laws. How should they handle all this? Should they use the highest bar?
Yeah. It is a hard question to answer for a privacy advocate, because I know that dealing with this different world, privacy laws can be a nightmare sometimes. But I will give you a short summary on the privacy landscape in the world before I answer this question. So we saw a big wave of privacy laws right after GDPR, the European law. And we had the LGPD and CCPA following this path of data protection. And of course, we have some similarities between LGPD, GDPR, and CCPA, especially in the area of individual rights. But in the US state level, California influenced other states to propose similar legislation. As you know, Virginia as well had passed one similar law to CCPA and GDPR, and other that have bills in the legislative path, like Minnesota, one similar to CCPA and GDPR, and others that have bills in the legislative run, like Texas, Illinois, Florida, New York, Washington, and much more bills similar to CCPA. So we also have laws outside of the US that affect businesses and must be considered, such as China's amendment to the Civil Code to include more privacy provisions, and China's cybersecurity law that will come into force in May 1st of this year, and requires that data stays in China and be only transferred internationally if reviewed by the Chinese authorities. So it is critical. My point, I want to tell you that, because my point here is that we don't have the same culture, right? As you tell, we don't have the same supervisory authority, and we don't have the same courts. And in some jurisdictions, like Brazil, we don't have jurisprudence consolidated yet. So while you see in the EU, they have the expression data protection since 1995. So some local adaptation must be considered, because we do have some differences. So that means that I think we must consider two scenarios here, not only the multinationals, the big companies, but also the small and medium-sized businesses. So for big companies with a budget for compliance, I would definitely recommend the safest door, which is to have a project for each law when applicable. And it is much more easy when you pass through the GDPR compliance, I think. And for small and medium-sized businesses with no budget to have a dedicated privacy staff, I would look for tailored services. They call this data protection officer as a service. That would be like a privacy professional or a consulting firm that will work on demand, not like a full-time position. So this person would research those different laws and draft your privacy documents without creating a project dedicated for each country. And it is important because I need to say that you need to assess your business risks and the best way to mitigate them. So if you have someone you can call once a month to ask some questions, or maybe a couple of hours a month to give your employees training, for example, that can potentially avoid fines that could be a huge impact on a small and medium-sized businesses.
Yes, that's very interesting. I know that ANPD has opened a public consultation to regulate, how LGPD should apply to small and mid-sized businesses. Yesterday I was reading one of the proposals presented by SEBRAE, which is an organization that supports these smaller companies, and they actually propose that the companies should be exempted from having a DPO. They should be exempted from the obligation to record the processing of activities or having the PIA, the Privacy Impact Assessment. They propose a huge reduction in penalties. So some of them might make sense, but at the same time, we need to see if this doesn't really make the whole law void. They actually accept that there should be exceptions to these exemptions, like when for instance the small company is really in the business of selling data or or collecting data, and of course, and that's a different. It should be treated differently. But do you have any expectations on how this should be addressed by ANPD?
Well, as you said, I think they have a more friendly approach, because they want to teach you how to manage all those things, because it's very new, not only for the ANPD, but also for the companies. So I think I saw some statements from the directors saying that they will bring like a collective knowledge on that before they start the fine. So I think that will be the beginning, but we must be attentive that there's not only the ANPD, right, but we have also the courts. So it is important to be compliant.
Thank you. Moscati, let's get back to the programs for adaptation to LGPD. In your view, are companies in Brazil adopting automated tools or automated solutions to address, the various challenges of LGPD, like data mapping, obtaining of consent, and so on?
So, Adriano, so as when we started the discussion, we discussed about the low level of compliance of Brazilian companies. So having said that, there are companies that are indeed investing in technology. As an intermediary of between these companies and the software and solution providers, what I'm learning and what I can share is that different technologies serve different kinds of business, and with a huge range of price and sophistication. So and also kind of support. So I think the biggest provider of data privacy solution in the world is OneTrust, and they have a solution that includes the support of several law firms all over the world, and several modules to attend different aspects of almost every data privacy law in the world. However, this comes with a cost and with a complexity. So I'm also a OneTrust certified professional, and you need to have some know-how to handle this these solutions. And I must say that not every business is capable of using these tools, and not every business needs these tools. Okay. So I think each business needs to understand what kind of tool is good for them or not. And there are other tools that are much simpler. They don't do any data investigation. So that tools that OneTrust has the model, LGPD now has a model, several US companies have models that they enter into the systems of a company. They capture the personal information there. You can track. This is very useful when you have a multinational and you have several databases. So the information can be stored in several places, and you receive a request, and you have 30 days according to GDPR, 15 days according to Brazilian law to get this request. If you have like a huge company or a company with too many databases, 15 days is not enough, and you need to have installed a tool to help you to capture and change all this information. If you are a smaller company, which is the case of most of the companies, you may not need that. So you just need the DPO screen that you classify the information and you show how you do this. And there's also a misconception because as Diana said, so many companies are not prepared. We don't have this culture. So there's this confusion between consent and interest and what you're required by law. So not all the information needs to be available and subject to available. Yes, you need to show to the owner of the information, but not all information are so volatile that the guy can ask to delete, etc. So you don't need that robust systems in most of the case you have in one database. So long answer, making it short. So there are really good solutions out there. You need to look for the right one. They can be quite inexpensive, so they are not all expensive. So you need to adapt the right solution for your case. And now the market is in so there is an explosion of solutions. There are many solutions out there. Few will survive. So I think you need to find the right one that you believe that will last, so will continue. Then you have the right support, and buy it. They can cost as much as, like, depending if you are in an association and you get together for the companies, maybe $300 a month. So you can find what is good for you. Be compliant with the law. You're never gonna be. So I'm the ones that would say, like, it's very hard to be 100%. But if you show that they're taking care of it, I think it's good enough in the eyes of the authority. It may not be good enough in the reputation. So I think the biggest challenge from now on will be to manage is how much you invest in security, how much you invest in systems to show that you're complying with the law, and not put into account only the penalties that, as we discuss here, most of the companies will not be in the radar of the authority, but it's under the eyes of the public. So this can destroy a company, the loss of their reputation in how they deal with personal information. So sorry, I think it was a long answer.
No problem. Very, very interesting. So let me ask Carolina about one legal basis that we have under LGPD that we do not have under GDPR, and I believe we don't have expressly in the CCPA, which is the legal basis. And for those who don't know, legal bases are the grounds that you need as a justification to be able to process data. And in Brazil, we have this one, which is credit protection. This draws a lot of attention from foreigners. They say, well, why do you need this? Isn't it included in the other legal basis? So where did it come from? Was it a lobby from the financial sector? Do you think, what's the purpose of it, Carolina?
Well, here in Brazil, we have 10 legal bases for LGPD, and it's exactly what you said, Adriano. There are 10 reasons that legitimize the use of personal data. So trying to fit the most reasons and why we have to use the data, why the companies has to use the data. So they are the structure of why we have to collect or to treat some data. So here, isolating the first two, they are the consent and the legitimate interest, the most popular. We have another 8 that are more clear and secure, we say, in a legal perspective. So the 10th of them is the credit protection. Well, I always say to every authority I meet that we have a division of the good customers and the bad customers. So we here in Brazil, we have a great level of creativity, and we do have a lot of hacking, a lot of fraud, and people are creative for both sides, so for the good things and for the bad things. So here we had to include this legal base, the credit protection, just to ensure that in situations of collection or debt incurred, the customer would not be able to use the mechanisms of the LGPD as a way to escape their financial obligations. I mean, This was inserted in this bill just to avoid the requests of data deleting of an debitor or if from an internal database of the bank, of the financial institution, or even from bodies such as credit bureaus, thus avoiding the collection. So yes, going strictly to the point, yes, we had a huge concern that the processing for credit protection would face this sort of risk, people who don't want to pay their debits, asking for, taking out their data from the databases.
Coincidentally, this morning I read a decision, a very short decision by a judge, which ordered Serasa, convicted Serasa, a credit rating score company in Brazil, to pay moral damages in the amount of 4,000 reais to a data subject, because in the package of information that Serasa was selling to companies, they included the telephone number of the individual. Mm-hmm. So the judge said that, they assumed that this was per se a violation of privacy and granted moral damages in the amount of 4,000 reais. So it's interesting to see how things are developing.
And this is huge. This is huge, if I may. This point of the mobile, the company telephone, these contact ways are being very, very discussed on controversial proportions. So how can I ask someone to pay something without having the contacting number or a contacting way? And judges are deciding like that. We cannot share the contact. The bureaus cannot share the contact. So it's really controversial for everybody.
Interesting. So new law, new challenges, and we have to pay attention every day what's going on, right? Yeah. So let me get back to Diana. We have a subject that we already discussed briefly earlier today, which is international transfer of data, a major challenge, everywhere. For instance, in Europe, a court decided that the privacy shield is no longer applicable or valid. So many challenges for US companies to transfer data from Europe to the US. And in Brazil, as mentioned before, the NPD has not regulated yet, has not listed which countries offer the same level of higher protection for individuals, and has not approved standard contractual clauses or global norms or standards. So there is some uncertainty on if multinationals can transfer data to Europe, to the US, to Japan, elsewhere. What should they do? Because consent is not always viable. So what should companies do under these circumstances?
Okay, first of all, I would like to clarify a little bit about international transfer because sometimes we cannot see it. So when we talk about international data transfer, it may seem distant, but it is a day-to-day activity, such as when you use cloud services, when we write an email and we include personal information. So it can be a day-to-day activity, but it can be international transfer of personal data, and you may be violating international law without knowing it. So now I'll go a little bit in the American context very quickly. Before GDPR, we had mechanisms to allow the transfer of personal data from Europe to the US. We had Safe Harbor, and then we had Privacy Shield that was basically a seal that allowed the companies to share data, but it was recently revoked, as you mentioned it. So without the Privacy Shield, companies are trying to establish other mechanisms. So what they are using basically is standard contractual clauses, because the European court decided that yes, Privacy Shield is invalidated, but standard contractual clauses are still a valid mechanism. But they are not using only the standard contractual clauses. They are ensuring that they have supplemental measures they call, such as encrypting the data before the data leaves the EEA, or disable access by recipients in the US, for example. So in this way, the LGPD brings that international data transfer can be carried out if it guarantees compliance with the principles, rights of the individuals, and the protection and a protection regime provided. The things that the transfer takes place, for example, from a country who has a different level of protection, right, from Brazil. The thing that the companies are doing now is they need to ensure that this international transfer will not negatively impact the level of protection. So some companies have used specific and highlighted consent for the transfer, as you mentioned it as well, with prior information on the international nature of the operation to individuals. But it is not the best way because, as the law says, the consent can be revoked at any time. So in some cases, what I'm seeing now is that companies, especially companies from the educational institutions, have used contracts. So since it is something that is essential to use, like the personal data is essential to use to enable the object of the contract, for example, the student's participation in the course. So it is necessary to inform individuals additional details about the international transfer of data, and especially when it involves sensitive data. But we have good news. The president of the National Data Protection Authority, Valdemar Ortuño, recently informed that the agency is evaluating issuing provisional authorizations for international data transfers. So while this issue is not regulated, so it's a good thing, I think, and we are wishing that it will be soon, right? So that's it. Yeah.
Great. So let me ask Carolina, which categories of data subjects presented the higher numbers of requests? I know you made a survey among banks and payment institutions, right, in the past, and you had some visibility on that. Can you share with us?
Sure. But first of all, it's important to have in mind that the LGPD idea is just to create a legal space that allows the adoption of legal regime similar to the international standards. So this is not the only initiative that we have now running in Brazil. We also have the open banking mindset that aims to put the person, the customer, in the middle, in the center of the relationships, as the owner of the data. So when we think about it, when we try to put the person and its data inside, in the middle of the discussion, we have a new movement of how to do that. So we have how can I say, we have not only discussed it, but we are living this here in our 100 of banks, that the consumer itself is the one that requests the most. And this happens because when analyzing this new scenario, the objective of the law and the this new mindset of dealing with the financial market, its products or service, people are moving to the new way of,
I think, well, we cannot hear
I
you.
lost her.
Yes, we couldn't hear you.
Can you hear me now?
Yes. So we're just finalizing your sentence and we didn't hear that.
Okay, so I was talking about this movement, the scenario. When customer agree to live in this new reality with consent, this is the word of the hype. They want to know what we stored, why we did it, and what for. So our major requests are totally with customers.
Right. Thank you. Isabel, I think we have another 10 minutes for some questions from the audience and also for conclusions and takeaways. Would you like to ask some questions, Isabel?
Yes, I do have a few questions to the panel. Thank you so much, Adriano. Maybe the first questions go to you then, Adriano. When we think about data subject, we tend to think more the external audience, but we do have employees who are themselves an audience that we have to protect in terms of individual rights. Can you tell a little bit more about what your clients are doing, whether they are using the same level of controls that they use for external and internal audiences, or is there anything different that they have to do with respect to the employees?
Right. Well, that's a great question. And in fact, most of the B2B companies, their real concern with LGPD is really with employees and actually former employees as well and candidates, right? So they are using the same level of care with their employees in general. That's what I have been seeing. But what's interesting is that generally with the employee, it's a little bit easier to handle because you have an ongoing relationship with the individual, so it's easier to take care of that. The challenge is really with the former employees and sometimes candidates. I remember that when the law came into force, Carolina made a survey with the banks, and in the first weeks, the major volume of requests were from candidates. They wanted to know what happened to my information. I was not hired, and what happened to my information. So I found that very curious. Now we can see, 7 months of law, we can see that many of the labor claims, the lawsuits filed by former employees, mention somehow something related to privacy. Sometimes, I don't know if it's really a legitimate request or not, but sometimes it's another tool for pressure. So I think you have a great point, which is the company should pay a lot of attention to that. And in my experience, they are doing that.
Thank you. Good to know. Diana, I'll go with a question that it's a two-pronged questions for you. First, well, overall, we want to talk about standardization of laws. Let's start with the U.S. Do you see in the horizon anything coming at the federal level so that we don't have to have this patch system of laws that go from state to state? So that's one question. And the other is, do you see anything coming that would standardize globally the laws related to privacy?
Well, it's a great question. I think that there is a movement in this way of having a federal federal law. This is because all the states are like, it is like the GDPR movement that you saw in the world. So here in the US, the CCPA is basically the GDPR So they're all trying to have the same level of protection, the same types of individual rights, the same type of requirements. So Virginia has passed recently a law very similar to CCPA and GDPR. And all the states are trying to also talk about this. I know that the Minnesota legislature is also talking with other states to make a pressure to have like a federal law that will be easier. And another point that is very important in the CCPA, CCPA, the Attorney General, before the law passed, they made like an economic impact assessment to know the economic impact, especially on the small businesses. So, and they discovered that it would be a great impact, but in the long term, it will be beneficial to the companies because it will be like an asset, like a competitive advantage. So I know that Florida did not make an impact assessment, and they were like criticizing because it is another law to add to the bucket, and the companies are like being crazy. Like, how can I do that? How can I comply with other laws when I have like a business that I have so many customers? So I see that there's no like a standardization of privacy law. Like, there's no movement in that direction, but you can see that there is a movement to a more data protection world. So they're basically copying GDPR initiative to change the world setting. So
interesting. So not one global law, but laws that are similar in terms of the principles that they apply. Okay.
Exactly.
Okay. Adriano, I guess this one is for you too. You know, when we talk about selling data in California, the selling there is so broad a term. When we talk about transfer of data in the GDPR world, that's so broad a term as well. Is there any initiative from law firms or any other consulting firms to perhaps prepare some kind of guideline to go through those terms and explain how broad they can be so that people can start understanding those laws a little bit more in kind of a self-study mode?
Well, I think that's a very interesting topic. I'm sure all law firms are doing this on a daily basis to their clients, right? But I think it could be an interesting initiative for the chamber for us to try to work on some guidance and help, the members of your chamber. That's something we can certainly think about.
Wonderful. Moscati, you talked about tools that are available to help everybody be compliant. And you did say that there are tools that are available to the small and medium companies. Do you see that already available, or do you see that it would take a couple of months or even years for those to be actually made available to companies in Brazil mostly, but also globally?
No, they are available. They are available already. So I see like 3 big families of tools. Tools that they have active softwares to search for information. They tag the information. It's like you put a hook on the information and you can control from a central control room. So this is more expensive and requires sophistication. You have tools that are just a Power BI, a spreadsheet, like have a really good looking, but you have humans putting the information, saying like, because not all the companies have like tons of customers. So many companies, if you're a shop like just and you have the customer walking in, buying something and leaving, you don't capture the name of the person. Okay. So, but then you have your employees. So you have tools that are simple as a spreadsheet that you put the name of the person and then the treatment, and you keep this, actually the cloud, it may appear that, oh, it's unsafe because in the cloud, but it's exactly the opposite, because you're behind all the shields that companies like Microsoft, Amazon, Oracle, they build. So you have tools that are just not really automated, and they're very cheap. And now I'm seeing a new family of tools, which I'm very excited, is that the owner of the information has in their mobile the tools to say, like, you can do this, you cannot do that. So this transfer part of the work to the owner of the information, the individual, the human, and the company just has a link. So, and this is extremely cheap. So it's just a matter of researching a bit, and there's a tool for every problem.
Wonderful. We are at the hour. I wanted to say to Carolina, it's just a comment, not a question, but I'm proud to say that Brazil has one of the strongest and most sophisticated financial systems in the world. So I do have the impression that we're going to be exceeding in terms of privacy as well. So that's my hope there. With that comment, I would like to thank all of you, Adriano Chaves, Diana Rosenberg, Jose Moscati, Carolina Rabelo. Thank you so much for participating in our event today. It was a very good discussion. I'm sure that there will be an opportunity for us to follow up with another webinar on the same topic, but addressing other issues. Thank you so very much. And thank you all for attending our event this morning.
Great pleasure. Thank you.
Thank you.
Bye.
Bye.
Bye-bye.
Thank you.